All right, hello and welcome everyone. Thanks for joining us here at the Center for Survivor Agency and Justice. We have a wonderful webinar planned for you today. As other folks are starting to roll in, we'll take the opportunity to go through just a few announcements before we hand it over. You are joining us today for a webinar on domestic violence in foreclosure, the foreclosure process, defenses, and alternatives for survivors. We're thrilled to welcome Karen Chapka to discuss this today, and we'll introduce her more fully in just a minute. My name is Sarah Wee. I'm CSAJ's Director of Research and Programs, and I'll be your host and technical assistant today. So I have just a few notes to get us on our way. We are recording this webinar, and everyone who registered for today's event will receive a follow-up email notifying you when we have the recording, the slides, and any related training materials posted to our website. That should be available to everyone by the end of the week, but you will also receive a direct email from me. And finally, I want to help orient you to WebEx a little bit. You will notice a couple of different options in the toolbar at the lower right. You should have an option to submit questions and answers. There's also a chat tool that you can access through the word cloud icon, where you'll see that I sent a note to everyone. And we encourage you all to engage, talk amongst yourselves, share your experiences, ask Karen questions. And regarding questions, we have some dedicated time at the end of today's training to have her address them. So send them in as you're thinking about them. CSAJ staff over here will be tracking them and compiling a little discussion list for us to revisit at the end of our time together. So please let us know what you're thinking throughout today's presentation. And so to get us off on the right foot, while we introduce what today is all about, as well as Karen, let's practice a little bit. Can everyone let us know who you are? What's your name, where you're coming from, what you do, what you're hoping to get out of today? Submit it through the chat and or the question and answer field. And just a little background on who we have attending today. We have close to 150 people registered for today, which is really exciting. And everyone mentioned in the survey just being really eager to get some concrete information to address some of these issues as they're appearing. So please let us know what you are experiencing and what you're thinking about and some challenges you might be facing regarding this issue today. And I'm seeing a lot of stuff come in. We've got folks from Louisiana. We've got folks from Idaho, Wisconsin. We're all over the place. So I hope everyone had a great full moon and first day of summer on Monday as well. Keep letting us know who you are, and keep using this chat because Karen will also be directing us with some questions and opportunities for discussion throughout today. So with that, I am going to turn it over to CSAJ's Executive Director, Erica Sussman, to kind of situate us for today's webinar. And thanks again.
Difficulty hearing me?
I'm gonna take a couple of steps back. Okay, everybody, apologies. We are all very happy to be in the same room today, and so we're just trying to maneuver some of the technology around that, so I appreciate your patience. Let me take a couple steps back and reorient us. So my name is Erica Sussman, and I'm the founder and executive director of the Center for Survivor Agency and Justice. CSAJ envisioned a world where all people have equal access to physical safety, economic security, and human dignity. Our mission is to promote advocacy approaches that remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. The Consumer Rights for Domestic and Sexual Violence Survivors Initiative is a national project of the Center for Survivor Agency and Justice. The initiative enhances economic justice for survivors by building the capacity of lawyers and advocates to provide consumer and economic civil legal advocacy and to engage in systems advocacy that removes barriers to economic security for survivors. We were first funded back in 2007 with some funding through the Office on Victims of Crime, and we're currently funded by the Office on Violence Against Women at the Department of Justice. The initiative provides technical assistance to legal assistance for victims, rural, and other non-governmental organizations that provide services and advocacy to survivors of domestic violence and sexual assault. We work with, and all of our work is really shaped pretty fundamentally by that of our powerful partners, and those partners include the National Consumer Law Center, Home Free, which is based out of Oregon, the Center for Court Innovation, Wider Opportunities for Women, as well as a cadre of expert advisors who hold expertise at the intersection of economic, civil legal advocacy, and gender-based violence. So the initiative carries out its work through a variety of different program activities, and I'm just going to very quickly highlight what those are right here, and you'll see that there are all sorts of links if you're interested in learning more about them. The first is that we are in the midst of developing a guidebook, a consumer and economic civil legal advocacy for survivors guidebook. That will be a comprehensive resource for lawyers, advocates, and other service providers interested in meeting the economic needs of attorneys, of survivors of domestic violence and sexual assault. We'll also be producing a series of advocacy briefs that are kind of a companion to that guidebook in short installments. We also host a number of consumer practice webinars like the one that you're participating in today, and this list here are some of the really foundational pieces and more recent webinars that CSAJ has hosted recently. We also provide individualized technical assistance, so very hands-on, intensive case strategizing for lawyers, advocates, and programs around the country that are interested in problem-solving some of the issues that come their way. And then lastly, our project involves really groundbreaking demonstration site work that is specifically focused on building partnerships and addressing the economic barriers facing survivors. And our current demonstration sites include the Texas Council on Family Violence, the Women's Resource Center in Pennsylvania, the Indiana Legal Services Low Income Taxpayer Clinic, as well as the University of Denver Law School's Civil Litigation Clinic. If you're interested in learning anything about the activities that I just outlined, there's lots of information on our website, and you're welcome to contact us. So, before we delve into the substance of the program, I just want to introduce our faculty today and give you a little bit of an overview of what we're here for. So today's webinar is focused on housing foreclosure and defense for survivors. We know that survivors of domestic violence face particular risks of foreclosure, as well as unique barriers to preventing or mitigating losses in foreclosure, which require all sorts of creative, legal, and advocacy strategies. And today's webinar is going to focus on providing you with some of the concrete tools to be able to engage in that work. We're really privileged to be joined today by Karen Chapkis. Karen is a supervising attorney of the Strategic Litigation Unit and directs the Home Ownership Preservation Project at Legal Aid of Western Michigan in Grand Rapids. Her practice is concentrated on consumer law, housing law, and mortgage litigation. She's also taught consumer law as an adjunct professor and is a frequent guest lecturer in the clinical program at Cooley Law School in Grand Rapids. In addition to that, Karen is the past chair of the Consumer Law Section Council of the State Bar of Michigan, sits on the steering committee of the Michigan Foreclosure Task Force, and has presented on mortgage lending issues for the Michigan Foreclosure Prevention Project, the Debtors Bar of West Michigan, the Michigan Conference on Affordable Housing, and the National Consumer Law Center's Consumer Rights Litigation Conference. So we are really thrilled to have Karen with us today. She has been a real integral part of CSAJ's work over the course of the past decade, and she'll be talking about some of the work that she's done with us and many of you over the course of the training that we have in front of us today. So without further ado, I'd like to hand it over to Karen.
Thank you, Erica. Let me just get over to the right slide. All right, there we are. So looking at who I've got with me today, and thank you to those of you who did the little survey when you signed up. It sounds like the bulk of the folks attending today have great background as domestic violence advocates and attorneys, but are new to foreclosure. So what we're going to do today is really try to give you a crash course in mortgages and foreclosure to at least get you somewhat familiar with terms and process, so then I can send you out into your respective states where you can go and hopefully get a little bit more state-specific information, but then be able to take this into your work with your individual survivors. As you sort of caught on there, I said I'm going to send you back to your own state. And the reason for that is mortgage foreclosures are very state-specific. While there's some federal overlay and more federal overlay in the last 2 years, the process and procedures are state-specific. And so to be able to really work with survivors, you're going to need to know sort of the nuts and bolts of your own state. So one way you can do that is the National Consumer Law Center does have materials available that sort of talk about each state's procedures, but I also do encourage you to go meet and make some new friends who do this work and who can sort of really give you the eyes on the ground of what's happening in your state. One thing about mortgages to know is sort of going back to the beginning. And if any of you have ever purchased a house or have worked with anyone who's purchased a house, you know you get that huge stack of documents when you sign up for that loan, and you have to sign your name a million times. A mortgage is essentially 2 pieces of paper. There's the note, which is the actual loan. That's the promise to repay money. I'm borrowing $100,000 to buy this house, and I promise to pay you back that $100,000 at 30 years at 5% interest and make those payments. But the second document is the mortgage itself. In some states, that's called a deed of trust, especially if you're down south or out west. And that's the document that is actually longer that says if you don't pay this note or if you don't do some other things that we say about in the mortgage, like paying your property taxes, then we can take your house. It's really important to try to figure out which of these documents your client or your survivor has signed, because the note and the mortgage sometimes don't have the same signatures, and that can become problematic. And so you kind of need to know what was going on, who was signing, and that kind of thing. It's also great to get that closing packet, and we'll discuss how to get some documents later on in order to get information about the transaction. For example, there's something called a HUD-1 or a settlement statement that's often in that packet where you can see where the money went from the transaction. So if, for example, if you had a party who put a large lump sum into the house and you need to trace that money coming into the transaction, or if money was used to pay off other debts or other items that you need to know, say, to equitably settle your property division, you can look at the HUD-1 to say, okay, $10,000 went to pay off husband's Discover card that was premarital, or whatever it is. If you need to trace out the money in the transaction, that HUD-1 or settlement statement is your place to look. One thing that's also useful to know is sort of who is who in the transaction. Mortgages tend to have a lot of players involved, and so oftentimes you need to know kind of who the players are so you know who you need to deal with and what kind of things are whose regulations, whose guidelines you need to know. It used to be we had a whole lot of loans that were fronted by mortgage brokers. They were kind of like real estate agents in a way that they, you know, your client would end up with a mortgage broker and they were supposed to look at loans available in the marketplace and help your client select a loan. Those were mortgage brokers are not as popular as they used to be because they've restructured incentives, but you still sometimes see a mortgage broker who's not affiliated with a bank. There's usually an originating lender. These are the folks who kind of front the money. More and more, most people are using the originated lender is also the one who's arranging the financing, and there's no independent broker. There's also often, after the originating lender closes the loan, you then sort of usually get passed off onto an investor or somebody else owns the loan. These are often your Fannie Mae or your Freddie Mac that you may have heard about, or sometimes there's private trusts, these securitized trusts that were traded around on Wall Street and kind of all led to the mortgage and market meltdowns in 2008. The most important entity in this whole thing is the servicer, and this is who your client's going to be working with on a day-to-day basis in terms of making payments, communications, who they're going to be talking with when things go badly. It may be the lender that they thought they originated the loan with. It could have been sold. It could have been sold multiple times with multiple transfers, but usually that's the person or the entity your client will know. Sometimes loans have insurance on them. The most popular of those is the FHA program through HUD. You may also see references to MERS, or the Mortgage Electronic Registration System, which is sort of a database that tracks some of these transfers. MERS will sometimes foreclose in its own name, and whether that's legal or not depends on the state that your client is living in. Going onwards. So the mortgage servicer is who you and your client are going to be dealing with. And one thing to know is servicers are usually split into a number of different departments. And you want to be able to sort of talk to the right department at the right time. And so a lot of the phone trees now are designed to route you in to the right department. For the most part, if you have a client who their mortgage is off track and they're looking at foreclosure or delinquencies, it's usually the loss mitigation section that you will be looking for and that you want to try to get connected to. There are some rules now that most of the large servicers have to have a single point of contact, an actual individual assigned to delinquent loans. There's varying degrees of compliance with that rule, but often that single point of contact will be in the loss mitigation department. All right, so to go ahead and try to bring this into something of a real-world situation, let's say you're working with a survivor named Janet, and Janet's going through a divorce. But in the midst of the divorce, she contacts you and says, hey, I've got a notice from the bank, and it looks like mortgage payments aren't being made. And so at this point, she's very worried that she's going to lose the home, and she and her children are going to become homeless. So as a question to the group, if you want to go ahead and respond in the box, what information do you think you need to know from Janet at this point to try to begin to assess her situation here?
Okay, great. So folks can start chatting their responses to this, and it can be really whatever, there's all sorts of answers, so there's no one right answer. So folks should feel free to chat in your thoughts about what you want to know more about Janet's circumstance. Okay, so one person is asking whether she's on the deed. Someone else is wondering whose name is on the note, what's the name of the bank and service. Another person is asking about how many payments have not been made, whether she signed a note or mortgage or deed, who the servicer is, what her income is, expenses, her employment status, whose name is on the mortgage loan. Does she know whether she is in foreclosure proceedings? Okay, some of these. Monthly amount, mortgage amount, how much is overdue? Lots of good questions.
Yes, great answers. All right, and so we're also going to need to know what we can tell Janet about the foreclosure process and timelines. So why don't we sort of launch into these two questions. The first one is gathering the information. So what do we need to try to get together so that we can try to figure out where Janet is and what we can maybe do to help her evaluate the situation. So first of all, you know, it's great to have the survivor bring you whatever she has. This is where you get the big grocery store bag of documents. And with any luck, you'll have the closing packet in there. You know, does she get monthly statements? Most borrowers will be getting monthly statements from their mortgage lender at this point. Is there an escrow analysis? Is our property taxes and insurance being paid by the mortgage company? And we can look at that analysis to see payment information. You know, any correspondence from the mortgage company, her closing packet. If you have a situation where she doesn't have it for some reason, she's not getting mail, it's going to the abuser, it's, you know, she just doesn't have it for whatever reason, we then need to sort of look at other places to get the information. One thing you can do is try to request it directly from the mortgage servicer. There's a process under what's called Regulation X, which is a CFPB, Consumer Financial Protection Bureau regulation. These were revamped in 2014, and you can do a request for information under that regulation, which is basically your borrower can send a letter, or they can even do it over the phone, but it's better to send a letter to the mortgage company or the mortgage servicer and say, hey, I need this information from you. So it can be a copy of the note, a copy of the closing packet, an accounting so that I can see where payments have been missed, any of those things. And the mortgage company or servicer is supposed to respond within a certain number of days to a request for information. Just so you know, there's also a notice of error process in that same regulatory authority, that if there's some sort of dispute with the mortgage servicer, they can try to resolve it through a very similar process. One thing I'm going to touch on here, and I'll discuss in more detail later on, is that if your survivor is not on the note, very often the mortgage servicer is going to say they should not, they will not give any information, that they're bound by privacy laws to not give information to somebody who's actually not on the indebtedness. You can attempt to argue that there is an exception under the primary privacy law, the Graham-Leach-Bliley Act, that they can have access to information if they have a beneficial interest in the property, which in this case is if they're an owner or successor owner of the property. It gives you a little bit of leverage to try to access that information. You can look, especially if you're in the middle of a divorce case, you can look at trying to do a subpoena to a third party, the mortgage servicer, the title office that closed the loan, those kind of places. And you can also look then, in that same litigation to get discovery to the spouse. Have them produce the monthly mortgage statements if they're the ones getting that mail. One thing that works fairly well is if you can't get the servicer to release directly to your client, to either request that the spouse sign an authorization, or if he's refusing to, have the court order him to sign an authorization, which then can be provided to the mortgage servicer to release the information to your client. So that's a couple different ways to kind of get the information that you need to sort of assess the situation. Somebody referenced budget and income information, and that's also information you're going to need, and we're going to talk a little bit more further down in terms of assessing individual situations and assessing individual options where that budget and income expense information gets really important. Basically, as a global overview to the foreclosure process, states either foreclose by judicial process or by a non-judicial process. Slightly more states do a non-judicial foreclosure, although the split is fairly equal. It's in the 20s somewhere. In those states that do judicial foreclosures, those tend to be primarily eastern and midwestern states, so like your Illinois, New York, Indiana, all have judicial foreclosures. The mortgage company, whoever owns the note at that point, has to go to court, file a lawsuit, serve that on the homeowners to then initiate a foreclosure. Usually before they do that, they have to establish the default amount on the mortgage, show that they have the right to have the home sold, and then they ask the court to sell the home and apply the proceeds of that sale towards the loan. Assuming that they can make those showings, then the court would enter a judgment against the homeowners, order that home sold, and move forward from there. The timetables for that vary greatly from state to state. There was a question when someone had signed up, maybe a couple of someone's about deficiencies, that there's money owing after the sale. Some judicial foreclosure states will allow a deficiency judgment, that after the home is sold, say there's still $20,000 owing. Some of those states will enter a judgment right away for the balance that's due. Some require additional proceedings, and some states don't allow that collection at all. So it's important to know what your state does on that. In the other states where they do a non-judicial foreclosure, these tend to be more of the southern and western states. Michigan is actually a non-judicial state. I believe Idaho is a non-judicial state. There's a bulk of them. These states generally do not require a court process. It's done outside the court system. In many of these states, it's by advertisement, where literally they just put notices in the newspaper, sometimes a notice on the home, sell it at a public auction. Many of these states have a deed of trust system, which is somewhat similar, but ostensibly there's a trustee running the situation who has some duties of independence. I know Washington State, for example, is a deed of trust state. I believe Nevada is a deed of trust state. That you sort of end up with these other people in the middle. So in those states, there's generally some sort of notice up front that the property is going into foreclosure, oftentimes a chance to reinstate or stop the sale, and then a foreclosure sale. In those states, too, if the house does not sell for what is owed, different states will have different procedures for then whether or not you can collect that balance that's due. And in most all those non-judicial states, they would then need to file a lawsuit to get a judgment if they want anything in addition to the house. So that's where I kind of tell you to go make friends with somebody in your state who does real estate or consumer or foreclosure work, so you can get the nuts and bolts of your state in much more detail. Know your timelines. Some states have what's called a redemption period after the sale, where the homeowner might be able to take certain steps to unwind the foreclosure and might have some options on the back end. In terms of defenses, and again, some of these are federal, some of these are a little state specific, but just to give you an idea of lines of inquiry, there's oftentimes defenses to foreclosure that are grounded in what happened at the time the loan was made. And these are often, the predatory loans that were very popular in the last decade. That there are violations of disclosure laws, that there's violations of substantive provisions of law that don't allow certain loan terms. All sorts of violations potentially that you can look at the origination, and this is where you want to figure out who got the money, who was involved, were the homeowners told something that wasn't delivered, do the papers tell a very different story than what the client thinks they had gotten, and start to piece through whether there was a violation of these consumer protection laws, if there was just good old-fashioned fraud, if there was something in the way this loan was made that could then possibly used as a defense to having to repay part of the loan. Then there's a group of defenses that have to do with what happens during the loan, the servicing of the loan. Things like how are payments applied to the loan. For example, I had a case once where my client had a job ended, cashed out the 401k at the end of the job, sent a check for something like $6,000 to his mortgage servicer, and on the accounting we could see it come in, and then it disappeared off the ledger. So he was looking very, very behind on his payments, even though we had made this very large $6,000 payment, which should have covered almost a year of payments because it was a very low payment. So those kind of issues. Whether there's forced place insurance, usually it's a condition of the mortgage to have property insurance, but oftentimes those mortgage companies seem to lose the proof of insurance, and so it's important. Sometimes they try to put these very expensive forced place policies on homeowners, and the homeowners often are paying double, or these forced place insurance policies are very, very expensive for very poor coverage. That might be an issue about how they're doing the insurance charges. There's often other charges to the account. I sometimes call these fee for the fee fees, because it seems like once you start a fee, they kind of multiply like rabbits. So those kind of things. There's also, and we're going to talk about this a little bit more detail, but failure to comply with some federal regulations that now require that servicing and loss mitigation, or the process of trying to work with a borrower to adjust the loan, that they have violated these rules and processes. For example, a dual tracking violation would be where a homeowner is applying for a loan modification and trying to adjust the terms and working with that mortgage servicer, but at the same time, the mortgage servicer is plowing ahead with foreclosure when they shouldn't be. So it's important to look at what the servicer is doing over here as well as what they're doing on the foreclosure track. As clients are working on negotiating new terms of the mortgage or repayment agreements, sometimes we will think we have an agreement and that we have sort of an amendment or a modification of the contract, but then the mortgage company can't manage to get that into the computers and fails to recognize that. And then there's also often good old, vanilla breach of contract claims that, again, can be asserted as a defense to the foreclosure and reasons why the mortgage company cannot foreclose. Then the third big group of foreclosure defenses are defenses that relate to the actual foreclosure proceeding itself. That there's not actually a default. You do sometimes find that they're foreclosing a loan that is current. I actually have a case like this where we showed a foreclosure when the homeowners were not behind on payments at all. The computers just goofed. There are issues, especially in some of the in some of the judicial foreclosure states like Florida, about who is the appropriate party to file a foreclosure, the whole who owns the note, who's the right party to bring an action to enforce the mortgage. There are sometimes other defects in the foreclosure process. They missed a step in advertising. They only advertised for 3 weeks instead of 4 weeks, or they've done something incorrectly in the process themselves. It's also, again, another thing that's important to know is that some individual states, some individual localities and courts have set up mandatory negotiation or mediation programs to sort of bring the mortgage servicers and the borrowers all to the table, get them to try to talk to each other and to see what they can do and what they can agree to try to avoid foreclosure. That can be a great way to communicate with a servicer who can also often be a little hard to get to the right person. So it's a good thing, again, to figure out whether your local units have such a mediation or negotiation procedure that you can use. There was a question in there about states that recognize a right of redemption. The redemption rights are something that varies state to state, judicial to non-judicial, so you would have to check in with your state. Some states have 0 redemption rights, and some states have substantially longer redemption rights. In Michigan, for example, we have a 6 to 12-month redemption right, depending on what kind of property it is. In terms of raising these defenses, in a judicial foreclosure state, it's pretty easy because there's a lawsuit, and you can just go ahead and defend that lawsuit, do an answer, maybe do a counterclaim. You're already in court. It makes it a little bit easier for you, and because you can raise some of these defenses, raise some of these issues defensively, you can have a little bit more flexibility in terms of pleading defenses or pleading claims as recoupment and not run into some of the statute of limitations issues. In a non-judicial state, obviously there's no lawsuit for you to just go respond to. You're in a situation where you're going to have to go file your own affirmative lawsuit. That will often mean trying to get some sort of temporary restraining order or preliminary injunction to halt the foreclosure sale while your lawsuit is pending. And again, beware your statute of limitations, statutes of repose, and other limitations. Many consumer protection statutes, especially at the federal level, have pretty tight statutes of limitations. A lot of them are only 1 to 3 years. So that may complicate what claims you may have and when you may bring them. Some states have also developed case law and rules about when and where you can challenge foreclosures. And so if you're too far in the process, it may be difficult to bring a challenge to a foreclosure that's complete or nearly complete. So that's an issue that you would want to know about how quickly you would need to act. This is not a presentation on bankruptcy because that would probably be a whole other couple hours, but I do want to mention bankruptcy because it can be a really useful tool, and hopefully once the guidebook is finished towards the fall, we're going to have a whole chapter on bankruptcy to give myself a little plug since I helped write that chapter. Basically, bankruptcy, the one nice thing about bankruptcy is when you file a bankruptcy, it stops all the foreclosure proceedings right then and there. No questions. You don't need a legal theory. You don't need a TRO. You just need a bankruptcy petition. So it makes it really, in some ways, to the extent bankruptcy is easy, it makes it really easy to halt something in its tracks that could be otherwise very hard to derail. There's basically 2 kinds of bankruptcies consumers file, a Chapter 13 or a Chapter 7. Most individuals who are looking to save the home would be looking at a Chapter 13 bankruptcy because that helps you set up a payment plan to get that mortgage current over 3 to 5 years. And in some cases, if there's a second mortgage, you might be able to adjust some of the terms or strip the second mortgage. that can be very useful and make a home affordable, especially if it's an underwater or there's second or third liens taking up all the equity. Bankruptcies generally do need to be filed prior to the foreclosure sale in order to stop the foreclosure sale. So what I tell my staff is an hour before the sale, you can stop it. An hour after the sale, you're over. So it's important to know that timing. But it is important to know that the bankruptcy court has very limited jurisdiction over most mortgages for primary residence. And so they can't force a rewrite of the loan terms, which is what a lot of survivors who have decreased income need. So in order for a Chapter 13 payment plan to be successful, the borrower is generally going to need to have sufficient income to cover those payments plus something towards what's past due, because there's this whole plan that needs to be structured. But if you do have a survivor with some money, it's something that you can look at whether that's going to be a useful tool for you. The Chapter 7 bankruptcy, which is what most people are more familiar with, is where you ask the bankruptcy court to essentially wipe out debts without requiring the survivor to have to repay a lot of those debts, assuming they don't have any significant assets or income that would give them an ability to pay. The problem with Chapter 7 is while it may be a short-term stop to the foreclosure, because it doesn't give us a payment plan or any way to deal with the mortgage, it's not a long-term solution, although it can be a short-term breather. But if you have a client who's been through foreclosure and is now facing collection efforts on a deficiency or remaining balance, Chapter 7 can also often be a nice tool to clear out that deficiency and get them out from underneath that house and that mortgage that they lost to the foreclosure. All right. I mentioned this a little bit before, and I want to come back to this because this is a huge, huge problem as you're trying to work with survivors and gather information and in the next step potentially trying to work with mortgage servicers, is the problem of not signing the note. And this is why I said before, and I think a couple of you identified in the comments, why you need to know what your client has signed. Because it's a very often the case where a survivor may have signed the actual mortgage, the actual, I give this bank the right to take this property if we don't pay, but they didn't actually sign the note, which is the loan and the promise to repay. And if she doesn't sign the note, the mortgage servicer is going to say, you're not really a borrower. You didn't really borrow this money. We're not going to tell you anything because we think it's bound by privacy laws, and we're just not going to work with you at all. These are the most complex situations to deal with. A couple things, and it could honestly be its own 3-hour session on what to do with these cases. So first of all, I highlight it as an issue of if you identify a case whether you've only got a signature on the mortgage, not the note, or even honestly the worst case where you don't have any signatures anywhere, that you didn't own the property, then you're going to have a problem, and you probably are going to need to, if you're new at this, try to pull in some backup. National Consumer Law Center has some great materials on dealing with these situations. So a couple things to know. First of all, the transfer of ownership to a survivor does not trigger a due on sale clause. Most mortgages have what's called a due on sale clause, that if I own a house and I sell my house to John Smith, then the mortgage company does not necessarily have to deal with John Smith. The mortgage company can say, oh, you had to pay us this whole mortgage because you've just sold the property. But there's certain transfers that by law do not trigger a due on sale clause. So if I own a house and I die and John Smith is my husband and inherits my house, then that is that's a non-exempt, or that is an exempt transfer. That does not trigger the due on sale clause because of death. A divorce is another situation that does not trigger that due on sale clause. So you should not have a mortgage servicer saying that your survivor has to pay the whole mortgage at once in order to keep that house. Okay, so that's the good news, that, you know, theoretically your survivor should be able to just keep making payments on the mortgage loan, the servicer should keep accepting those payments, and everybody should be fine. The stickier issues are if your survivor cannot afford to make those ongoing payments, or there have been some payments missed. What obligation does the mortgage servicer have to then work with your survivor other than just accepting their money? The new, and by new, the CFPB regulations that went online in 2014 have some guidance and have some provision to deal with the situation of a widow when there's a death, but unfortunately they did not extend that language to also cover divorces. There are some proposed regulations that we can talk about in a little bit that look to expand that protection, but it's really not in place yet. I encourage you that to the extent you're seeing these problems, that you let the CFPB know that you're having problems in these divorce situations so that they can understand that their proposed regulations and any future regulatory activity that they take into account these issues of divorce and domestic violence. And as many of you know, most government agencies work by volume, and so the more they hear about the problems, the more they'll understand that these problems in fact exist and are not isolated. The Consumer Financial Protection Bureau has a very nice website. It's very easy to complain on their website. They've made it very easy if you have a computer. But what some of the loan programs allow us to do in the case of divorce as well as death is that they create a situation where the survivor has a right to assume the mortgage even if the loan is in default, and that assumption cannot be blocked based on creditworthiness. So if your survivor has a much lower credit score, they should not be using that credit score to stop the assumption. And then generally they can look at doing a simultaneous loan modification or doing something to try to correct the default in the loan at the same time they're doing the assumption. These are hard and they require a lot of vigilance. The last one I did took 3 years to get through. So they're not for those who don't have a little bit of fight for them, but the industry is moving slowly towards recognizing that they need to have processes in place, and it's incrementally improving. There's lots of legal claims bound up in here, though, even without the CFPB regulations, you know, whether we have violations of fair housing law, violations of the Equal Credit Opportunity Act, because predominantly the individuals in the situation are women. And so there's lots of possible legal claims bound up in these that you can help your clients look at bringing. And again, I would encourage you to reach out to some of the specialists in consumer law and the NCLC to learn more about this situations. Okay, and I just looked at the time and I'm going much slower. So on to the next section. So Janet has decided that she would like your help to help prevent the foreclosure and would like to know what her options are in terms of trying to move forward. So what kind of things do you think you need to know now about that, and what are some of the options you think that Janet might have in terms of trying to prevent the foreclosure? And also, if you want to think a little bit too about how some of these options might fit into an overall safety plan for Janet to make sure that she is safe. So if you want to go ahead and type those in the box, and Erica and I will see what ideas you have. You had such great ideas in the first one.
Great. So, yeah, feel free to jump in and offer some thoughts about, again, information that you need to know in order to assist her, what some of her potential options may be that you'd want to talk about with her, and ways in which you could tailor some of those options to mitigate some of the safety risks that may be present and to fit within her larger safety plan. Okay, a loan modification, need to know if in court for foreclosure and if an answer is due so that we can slow that down. Okay, so that's about the court process, getting some information about the process. Is her name on the note?
Yes. Good.
That's all we've got right now.
Good. All right. Well, there's a few people awake out there. It's always so hard on these webinars since you don't know. I can't see faces, so I need to be able to do this by Skype or something. All right. So basically what we're doing here is we're entering the world of what's called loss mitigation. Loss mitigation is a process that has been developed over several, honestly, decades. And one thing to remember is that loss mitigation wasn't originally designed so much to prevent the loss of the home to the homeowner, but to prevent the loss of the money and the loss of the investment to the mortgage company, okay? So they're going to be viewing things from that lens of, we don't want to lose money if we have to foreclose. Is there something we can do here that will make more money for the financial institution in the long run? I can't guarantee that your bank or your mortgage servicer will actually do rational things, but theoretically that's the lens in which we're looking. So in terms of loss mitigation options, there are basically two universes, the ones that will help her keep the house and the ones that will prevent foreclosure but means that she's going to have to give up the house. So we need to know a lot more about the individual homeowner to know where we're going with these. And so one thing is to know in terms of the income, and the reason why these payments aren't getting made are these short-term or long-term issues. In a divorce situation, we often see a reduction in income. So is that going to be a long-term situation, or is it more of a short-term once we can get some child support going or get some hours increased work, are we going to see a return to a better income level? Or are we looking at sort of a long-term, she's never going to really get child support for whatever reason, that we're looking at a long-term decrease in income. So that will help you sort of sort out, okay, are there things we can do? Do we just need a short-term repayment plan? Do we need long-term restructuring? Or are we at an income level where this is just never going to really be doable? Okay? Because then the options are going to vary somewhat depending on who our players are in this mortgage, how much equity we have or don't have in the house, how far behind are we on payments? Are we just one payment behind, or are we 3 years behind, and those kind of things. The best time to sort of attempt to do this is obviously sooner rather than later. It's a lot easier to try to work with these situations when we're only 1 month behind versus the sale is tomorrow. But, wherever your survivor is, there's nothing to be lost really in trying to work through an option to see where you can get, even if it is sort of a last-minute attempt. All right, let me, my mouse is not wanting to advance. There we go. One thing that has changed fairly recently is that in 2014, when the new CFPB regulations about mortgages came online, they established a federal regulation that creates a uniform process for how mortgage servicers have to process a loss mitigation request, a loan modification, short sale, whatever. The regulations do not mandate an outcome. It does not say if you have a borrower who looks like this, then you need to do this. Instead, they say if you have a borrower who is making a request, these are the things you need to do next, and these are some timelines that you need to follow to make sure that you do something timely. It covers most first mortgage for owner-occupied homes. So it's not going to cover investment properties if you've got someone with more than one house. There is an exception for very small servicers. If you've got a really super local bank who does not do a lot of loans, they may be a small servicer exception. I think I've run into one in 2 years, and they were a teeny tiny bank. So that's not going to give you much trouble. Where you may run into trouble is if you represent senior citizens that have those reverse mortgages where they don't have to make monthly payments. If you have a second mortgage or a HELOC, a home equity line of credit, the regulations don't apply to those second mortgages downstream. One thing that's important to know is these rules mandate certain communications to the borrower at certain stages in the delinquency, but it also says that mortgage servicers cannot proceed with foreclosure until that loan is 120 days past due. So that gives you about 4 months for someone to figure out there's a problem and to start to work with the problem before you jump into a foreclosure situation. So under these loss mitigation rules, once an application for a loss mitigation or loan modification is submitted, the servicer must acknowledge that they received that packet and let the homeowner know if the packet is complete or incomplete. And if it's incomplete, what additional information is required, and provide a reasonable deadline for submitting that additional information. If the application is submitted more than 37 days before a scheduled sale, then the servicer must evaluate 4 available options and submit a written decision to the borrower within 30 days. And this is kind of that dual tracking that they are not supposed to, on one hand, be saying, oh yeah, we'll look at your loan modification, but on the other hand, keep going with the foreclosure and have the foreclosure happen first. They're supposed to get through the loss mitigation evaluation piece of it first, assuming that the homeowner is getting that stuff in a timely manner. There are some appeal rights if the servicer makes a decision with which the homeowner does not agree, depending on where you are in the timeline. And then there's a little bit more on the dual tracking rule for you. Typical loss mitigation information includes budget information. Under some programs, this is called the Request for Mortgage Assistance, or RMA. That's a form. It's usually about 7 pages that folks are often asked to fill out. There needs to be some sort of letter of hardship. They usually want a documentation of why the homeowner got behind. Divorce is generally considered a hardship. You know, being a victim of a crime and having to take time off work, I think, would be sufficient hardship. You know, you have to show that basically something happened to the homeowner that was not the homeowner's fault, that was involuntary, but that's the reason they got behind on the mortgage. It's not just that there is a concern in the industry that people will stop paying just to get a better deal. So that's part of why they're looking for some documentation of the hardship to make sure folks are, for lack of a better word, sort of being honest about their inability to pay. They'll often want documentation of income, tax information, bank statements, and that kind of thing. Now, where it gets tricky for our clients is that if the debtor, if the abuser is on the loan, we may need his cooperation, especially if either a divorce is not finalized or if they were never married and we don't have a very good way to transfer ownership or to show that he is no longer involved in the situation. And that may mean that he needs to sign a quitclaim deed to give up his ownership interest in the property so she can then be the sole owner. It may mean that he will have to sign off on a loan modification if he's on the deed and there's no good way to get him off the deed. So that's something you're going to need to discuss with your survivor is, you know, especially in those, you know, not divorced yet or never married so we can't divorce, what level of cooperation can we expect? what are going to be his conditions for that cooperation, because I've seen cooperation premised on very unacceptable terms. Is asking for that cooperation going to put her in danger? Those kind of things will need to be discussed and sorted out, and where are the goals and where are the safety issues. However, in terms of working with the mortgage company, the big issue is especially if she's trying to keep the house, is to be able to show the capacity to make mortgage payments given what her current situation is and what we can expect it to be. And as we've sort of referenced before, what you're always looking to do is try to get a complete application in, because you're going to get the maximum protection from foreclosure if you have a complete application that is in for evaluation. They're supposed to evaluate it within 30 days. I don't know that I've ever actually seen it evaluated in 30 days, but they're faster than they used to be. We referenced this a little bit before, and here is in terms of trying to come up with some better regulations in the event of divorces and domestic violence. There were some amendments to the rules. The amendments were in March of 2015, the comments were due. So we submitted comments praising some things that the CFPB had proposed that we thought were great additions and protections into the regulations, but also proposing some different things to try to make them better, to try to make sure that our clients had the right to take action for those violations, so they have a private right of action. There's the first page of the letter that we sent for those comments is on it. The full comments are on our website, on CSAJ's website. We have not heard anything really from the CFPB since the comments closed over a year ago. So again, I would encourage you, if you have clients who are having problems, to keep reporting those to the CFPB, to keep the pressure onto them that this is an important issue, that they need to look at our comments and hopefully take appropriate action in their rulemaking. I'm going to skip through some of this because we're starting to get short on time. Just one thing to be careful of is really encourage your survivors to be honest with themselves. So often people want something desperately because they have visions of what they want for their lives. They want to keep the house at all costs because they think that will put them in a much better position, say, to retain custody of the kids or these other very important things to them. And so, but at the same time, it's not going to help anybody if they overinflate their income and they try to get themselves into a situation where, you know, they're willing to accept a payment that's at 2/3 of their income, which is very unsustainable because of this desperation, but we end up in a worse position financially. We end up, you know, without being able to plan for these things. It's really important, no matter how hard these situations are, to try to encourage your client to be just very honest about their resources, their goals, and to help them work through those things. I mean, our homes are so important to us, especially to a survivor who may feel like very much like everything is kind of getting lost and at risk, but it doesn't really help anyone if we aren't honest and we're trying to look at a solution that may never actually work. So that's just something I always really encourage, and that may take a lot of meetings and a lot of really tough conversations over an extended period of time.
Karen, this is there. Karen?
Yes.
Yeah, hi. So I just wanted to chime in because I think you've raised a really interesting and complicated area of client counseling, and I guess I'm just curious about whether this presents some really important opportunities for partnership between foreclosure attorneys and domestic violence advocates and family lawyers too. I know that you mentioned the fear that many survivors might have around custody and how that relates to their housing and economic stability. So it seems to me like it would be a really important, you know, while sort of economic practicality is absolutely critical for people in terms of securing their own financial stability, we also know that the other risks that survivors face have to be kind of weighed and thought about really carefully, and are going to be so different depending on the person. So when I'm thinking about this, I'm thinking about how, particularly where there are custody issues involved, or perhaps other issues as well, that it might be a really important moment for there to be some conversation with domestic violence advocates and family law attorneys and the survivor, of course, being able to articulate her own priorities so that all of that can be weighed together and thoughtfully.
Absolutely, absolutely, because, you know, there's the legal pieces of this, but there's so much more about, you know, what are her goals, what are her motivations, what are her most important goals. If we have 5 goals, which one is number 1? And if she's sort of making up goals 2 through 5, thinking that they'll get her more to number 1. It's also sometimes great, you know, if we have several professionals working with the survivor, you know, sometimes they're much more willing to are much more able to connect with one. So, you know, some programs who have more like peer mentors, sometimes a survivor feels like they can be much more honest with a peer mentor or an advocate who doesn't always have all these fancy letters than they can with somebody who's got the letters, and they feel like, oh, this person wants to hear right answers, so I'm going to just tell them the right answer so they'll keep helping me because, you know, they've got the fancy JT at the end of their name. And so sometimes it's useful to, you know, have all the professionals kind of on the same page to the extent the survivor is willing to authorize that communication, because that is something she'll need to authorize, to say, okay, you know, the survivor is saying to the advocate, like, I don't care where I live, I just want my babies with me, but telling the attorney, oh, I need to keep the house at all costs, you know, and then being able to connect, okay, well, it's really because, you know, she wants to keep the house because she thinks that's the way to keep the kids. Okay, now how does that interplay with the custody determination and whatever factors the family court is looking at, and, you know, to put all that together. But often I find clients with multiple advocates may sometimes connect with one a little bit better who can be the best person in the team for those conversations. But it's also really good for whoever's involved to start to say, you know, there are multiple options. If your goal is this, we can still get there. Some people need to be told it's okay to let a house go, that it's not a huge moral failing that will follow them forever. Some people really need to hear that out loud and to have those conversations about what would life look like if we walk away from the house, or if we sell the house, or if we don't fight for it, because it's just not a good idea, either financially, safety. You know, if you've got a client who's just really never going to be safe, where her batterer knows precisely where she is, you know, very much, it's okay to walk away from those kind of things. Yeah, so putting all those pieces together is so important.
And I think holding all of those pieces at the same time, because when we talk about building trust with clients, we know that clients are going to be more likely to tell us what they want when they feel that we have a particular goal in mind. But if they're sitting with one or more professionals who are, you know, saying, yeah, we hear you on this front in terms of you're wanting to stay in this space, we're also listening to you in terms of your concerns around custody, and hearing all of those pieces together, then they're able to kind of rest a little bit easier, knowing that they have an advocate who is considering all of the moving pieces.
Yeah, yeah.
Complicated and complicated stuff that makes this work so interesting and rewarding.
Yeah, yeah. It's good. So often people don't know that there's lots of options. And so even sometimes just giving them permission to look at other options can just sort of shift their perspective and be freeing for them. All right, so I have listed lots of different options and what the names are. The loan modification is what most people know about, and those are certainly available under different programs. You know, in terms of options where they would give up the house, most of those are looking at some sort of sale, whether it's a regular sale, which can be great if there's equity in the house to make sure that equity is preserved and then available for the survivor as she moves on, but also, you know, in terms of a short sale, if they're upside down or if they owe more than it's worth, to try to get out from underneath that indebtedness, but hopefully walk away without owing anything and without a foreclosure. You know, again, working with the survivor to look at ways to access financial resources, whether that's, you know, spousal support or child support type thing. Are they eligible for benefits? You know, renting a room, some people do. Obviously, that has its own set of safety issues, but sometimes, you know, people will rent to, you know, mom or an aunt or somebody to try to increase the income. You know, working with them and hooking them into agencies to hopefully access employment opportunities, especially if they've been like a stay-at-home mom or been in a situation where they weren't working outside of the house. Some different states have different financial assistance programs, including a hardest hit program, which is federal funding that many states received to assist homeowners with getting mortgages current. I'm going to kind of skip through that, but just in terms of thinking through our options for Janet, you know, again, one thing to be very careful is, you know, is that where is her hopefully former partner in all of this? You know, is he going to cooperate with things that she wants to do, either in the divorce context, after the divorce, or if they were never married? What is she going to need his cooperation on? What can she do without his cooperation if he either won't cooperate or it's not safe? And other things you can do to assist with that safety planning. Erica put up some great resources for this. But again, this is one of those things that your client is the expert. She is the expert on him, and how is he abusive, and in what ways is he abusive, and what his triggers are. And so she's going to be the expert in telling you, okay, like if we ask him to sign this, what is his reaction going to be? If we need this from him, is that going to be safe or unsafe for you, to help assess those risks? And then, you know, to then make the determinations, you know, is foreclosure prevention going to be possible? You know, is it safe for her to stay in that house? And again, to have that conversation that it's okay to leave, because there are many things in life that are more important than those four walls. And if that's where these conversations lead, to then help her be okay with that, and then to help her access resources to move into the next step. You know, another thing you can do is to look at the family courts, where actually most of you are more of an expert than I am in terms of using these family court proceedings to help prevent foreclosure or to deal with the house. Whether that's sometimes family courts will order the spouse to pay the mortgage as part of or in lieu of spousal support, have the family court order cooperation with loss mitigation, that they have to provide certain documents, that they have to sign an authorization, what have you. One thing to note is that some state laws do allow a transfer of real estate with just a judgment of divorce. The mortgage industry and the title offices hate that. So if you are doing a divorce and your state's practices to transfer ownership in the judgment, always get, if you're able to, get a quitclaim deed or some sort of deed signed by the husband or partner to transfer that property, because judgments of divorce just confuse the mortgage companies. If you can get that just extra piece of paper, it's going to be a lot easier to deal with. One thing that folks often have questions about is how do we get the abusive partner off the mortgage loan? That's often a question that they have, a requirement that the abuser has. The family courts are often very sensitive to that idea of, well, okay, if the wife is getting the house and she has to pay for the house, we don't want that on husband's credit record or affecting him in the future. And the problem is that it's really hard to get the abuser off the mortgage loan without doing a true refinance of the mortgage loan, which unfortunately, if we are discussing foreclosure, chances are her credit scores and such are not going to make her eligible for a refinance. So what I try to do is to work with our attorneys and have them try to explain to the family court, you know, some requirements of getting a mortgage refinance. And one of those is usually that you have to have 12 months of on-time payments. So if the family court is looking at a requirement of refinancing this mortgage to get husband off, how much time are we going to need to do that? And trying to push that as far out as we can to try to get a 12-month payment history that's good and to look at the rest of the credit scores. We often try to work with some of our home ownership counselors who do pre-purchase counseling to kind of get a consult with them, like, okay, what does the credit score look like? What does the financial picture look like? How fast do we think we can get this individual credit worthy that refinancing makes sense? My mouse does not like this little button to advance slides. You know, looking, maybe that we look at the selling the property through the family court, and then how are we going to do that and divide the proceeds. You know, there is generally going to be a certain amount of cooperation required in that if we're going to sell the house. If the house does not sell for the home mortgage and there's a deficiency, who's going to be responsible for that deficiency, and if that's part of the property settlement in a family law case. Here's some other strategies that I've heard of from other folks. I believe the first one is sort of based from our California advocates, is trying to bring in a mortgage company into the family law case to join a third party. So they're kind of at the table. Because normally a family court would not have jurisdiction over a third party like that. Something that our colleagues in especially Illinois have been able to do successfully is consolidate the foreclosure case with the divorce case, because they're both still in court, and try to consolidate those proceedings a little bit to allow them to move forward together. And if you're in Illinois or if you're interested in that idea, I have a couple citations to some Illinois cases that I can email you if you want to shoot me an email. And again, looking at the court the family court to do things like compel signatures, you know, to get a temporary restraining order to require that the husband, you know, not to do things or to cooperate with sale efforts or to cooperate with loss mitigation efforts. You know, if you have a situation where, you know, the house needs to be sold, to work at the court to get those authorities for those kind of things. If you're not in a divorce context, you're going to then maybe have to look at a partition action to try to deal with that house and try to force the sale or to try to get one party off the deed, since you won't have a divorce court with authority to do that. You know, you can look at bankruptcy for tools, both with trying, you know, to deal with this intersection and whether using a litigation process in the bankruptcy court could be helpful for you, or some other ideas that people have had success with. again, I encourage you to make friends with the foreclosure attorneys. Some of you at legal aid programs, it might be just as easy as walking down the hall. Others, that don't have agencies that have a diverse services, it may mean, calling another legal aid program, looking at, the private bar and who's doing these cases to try to work with them so that you can bring your information and your fantastic knowledge about domestic violence and the dynamics of these relationships to the consumer and foreclosure attorneys who are often not going to have that background and are not going to always see the situation through that lens, which may very end up complicating their representation. And another thing you can do is, especially in those states with judicial foreclosure, although there's not generally any laws that give domestic violence victims or survivors special or, special accommodations, foreclosure is at its heart an equitable proceeding. And so if there's facts or situations that would give the court reason to create a different equitable remedy, to use its equitable powers in a different way, you want to let the court know that equity in this situation where there's domestic violence looks different than a case without domestic violence, whether it's giving more time, whether it's doing something different, trying to raise that information to the court in that equitable context can hopefully get your client in a better position for wherever she would like to be. You can help with gathering documents and information for the foreclosure attorneys, and help the survivor get some of that information which she may need. And with that, I do have a little bit of time for questions since I ran through that end really quickly. So I'd love to know if there were any questions. I've sort of seen a few comments in the box, but I haven't read very closely.
Okay, great. So there is one question that someone has asked. It says, do you think there is support for getting a judge to grant a stay of the foreclosure proceedings until a divorce is finalized in order to save the marital home where the survivor is living in the home with her children?
Yeah, I think this is definitely a situation where you could go to the foreclosure court and say, court, you are a court sitting in equity. We expect this divorce case to be finalized at X period. Once it's finalized, we should be able to then look at ways to avoid foreclosure, or there'll be a property settlement that will directly deal with this foreclosure or whatever it is. And so therefore, we're asking you to exercise that equitable authority to proceed with the foreclosure in a way that works with the divorce case. I think it will depend a lot on the judges involved. But I think it's worth asking, and I think some courts, especially if your divorce is going to be on a tight time frame, and you can tell the foreclosure court with some certainty, timelines that it's not going to be years, that it's going to be months, and to give them some reassurance that you're not asking for an indefinite stay. I think that some of those courts would be willing to work with you, especially if it looks like whatever's happening in the divorce is going to help resolve the foreclosure.
Okay, great.
Any other questions?
Yeah, I don't see any other questions right now. What measures are available for victims who have completed the divorce? Yeah.
Once the divorce is complete, most of the servicers have guidelines, like Fannie Mae and Freddie Mac have sort of policy statements on this about if we're doing like a loan modification or loss mitigation and I have a completed divorce that shows that my survivor gets the house, they will generally waive a lot of the requirements in terms of X providing financial docs, X providing signatures, X having to sign things. So it generally becomes a lot, assuming my client is on the note and I'm good on that issue, it generally becomes a lot easier to get through loss mitigation with the mortgage company once the divorce is finalized. It's when we're in the middle of the divorce that things can be really hairy.
Mm-hmm.
Unfortunately, we don't always have the luxury of waiting either. So sometimes you got to do the best you can where you are.
Yep.
And I would, just so we can let Karen finish up, please feel free to continue submitting questions, and we can also answer them by email afterwards. And I encourage you to complete the evaluation after this webinar and let us know of any other experiences or questions that may percolate after you've had time to kind of sit with all this today. So we can kind of address any other questions after today.
Yeah. I do see something from Rachel in the chat box about reverse mortgages. I didn't go into reverse mortgages because reverse mortgages are really weird beasts. For those who don't know that term, what a reverse mortgage is that for a senior citizen, age 62 or over, they can take out this reverse mortgage. Its proper name is a home equity conversion mortgage, which basically is they don't have, the main feature of it is they don't have to make payments as long as they're alive. They don't pay off the mortgage loan, but what happens is that when they either pass away or they're unable to live in the home anymore, then the mortgage company forecloses and they get the house, and that's how the loan gets paid off. Most of these mortgages are insured by HUD to make sure that there's not a loss to the lender. There's a formula that's used to sort of see how much money you can get depending on how old you are and what your prospective life expectancy is. So reverse mortgages are very different and very strange, and there's this whole HUD regulatory overlay because almost all of them are HUD insured. If you have a reverse mortgage, they can be difficult to deal with. There's been a lot of litigation recently about some of the reverse mortgage issues. A lot of that's by the AARP's legal foundation out of DC. So if you've got this reverse mortgage situation, Rachel, and you wanted to shoot me an email, is my email on this slide? Go ahead and get a CSAJ and they can pass an email on to me, Rachel, and I can see if I can at least give you a bit of guidance since reverse mortgages are so funny, and to see if we can get you hooked up with somebody locally who can maybe work on some specifics with you.
Yeah, I'll put our contact info in the chat right now, so if anyone wants some follow-up technical assistance, we can make sure to connect them with you.
Yeah.
Okay. All right, Karen, I know that you had some additional little slides in here on results. If you want to run through these real fast?
Yes. For assistance with loss mitigation, the HUD does have a network of certified housing counselors. Some states do as well. So you can call HUD and get information from counselors in your area. Again, these folks may not be trained on the DV and ITV aspects, but you can hopefully work with them because hopefully they'll know the foreclosure pieces of it really well. They can help you put together these loss mitigation applications, help with, are you eligible for refinancing, hopefully kind of act as you know, that intersection and an additional professional that you can work with. I do warn folks, though, that anyone who watches DA Team TV knows there's all sorts of scams being advertised of folks who are willing to take your client's money to purportedly help them with the foreclosure, but oftentimes those things are scams. And so I tell my clients and the folks who come to us to be very careful about anyone asking for a fee in exchange for those services, and that if you're seeing those scams, to report those to law enforcement, CFPB, and those kind of places. The CFPB has really done a great job of shutting down some of the national scams, so that's a resource for you. Many legal aid programs have foreclosure attorneys. as well as there's the National Association of Consumer Advocates, and their members, you can find their member information directly from their website. And those are folks that you can access. Most of the consumer law attorneys are fantastic in terms of sharing information and knowledge. And again, if you're in a particular state and you're looking for somebody, I do know attorneys in other states that I might also be able to connect to. And then contacting CSAJ for assistance and with help with trying to make some of those connections and partnerships. Other resources. Erica, are you doing this one or am I? Oh, I think you're doing this, Erica.
Thanks, Karen. So CSAJ has a number of kind of foundational resources related to economics and consumer rights. And they're all displayed here. One is our National Needs Assessment Report, where we surveyed about 220 or so lawyers and advocates, and I talked about that earlier. There's also our article on the economic ripple effects of domestic violence. There's a link to our pilot site report if you want to learn about some of the partnership building that we touched upon today in a variety of different contexts throughout the country. As well as CSAJ's assessment tool, which gives folks interested in really delving into this work a tool to better assess where they are, what their capacities are, and how they can do this work effectively, steps that they can take to do this work effectively. Those are some key resources, but in addition, I would just direct you to CSAJ's resource library, where there are tons of webinars that have been recorded, as well as many, many resources on different areas, including foreclosure amongst them. I want to just highlight some key resources around foreclosure. So right now we are in the midst of developing a guidebook on consumer and economic advocacy for survivors that will be released soon. And in that guidebook, there's a chapter that is specifically focused on foreclosure, but also it will contain many other chapters that address different areas of consumer and economic civil legal advocacy. So keep your eyes open for that. And then here are a bunch of other resources that come from a variety of different agencies and organizations around the country focusing on this work. This is one of CSAJ's newer projects, the Racial and Economic Equity of Survivors Project, REAP, which is a new initiative. And if you want more information on REAP, you can absolutely reach out to us. We'd love to share some more with you. And thank you for joining us today. We've covered a lot of really rich information. I'm so appreciative for Karen's expertise and knowledge in this area. You have given us a lot to think about, a lot of really concrete tools, and I thank you very, very much.
Thank you, Karen, and thanks, everyone.
Thank you.
Okay, take good care.
You too.